My lady, firstly, before we respond, it appears that substantively there is no opposition to plea taking, as we understand it. And my lady, that would then mean that we do first have the accused persons properly before this court, subjected to mental assessment, whereafter, my lady, we can now come back to effectively address issues of bond and bail and the other applications as have been made by Learned Senior Mr. Swaka with regards to release of some items. My lady, as it stands, and I want to agree with Learned Senior Mr. Paul Mboya that as it stands at the moment, that application is premature. In the sense that, my lady, we cannot at this stage be litigating on whether or not to release items that are properly in the investigator's custody. Items that investigators have probable cause to believe are to be used as exhibits before this court. And as such, those issues can only be addressed within the trial itself, my lady. Your Honor, as regards to the very serious allegations made with regard to torture as against the first accused, my lady, I was present alongside Learned Senior Mr. Swaka in Jomo Kenyatta at the Jomo Kenyatta courts when we handled the miscellaneous application for custodial orders. And Your Honor, an issue was raised with Mr. Swaka, by Mr. Swaka, with regard to some certain violations that had been committed while the accused number one was in custody at the Ruaraka police station.
During arrest or while he was in custody?
While he was in custody. That was the allegations that were made. While he was in custody.
Yes.
To the extent that the accused person was mostly always handcuffed even when in custody. But these allegations were made by counsel who sold an affidavit. They were made by counsel. My lady, that application was on the very day, the same day, withdrawn by Learned Senior. That application was withdrawn after the situation had now been remedied. The cuffs had been removed from the suspect. During that application, there was never a mention of torture that was being carried out while this suspect was in custody under investigations. Your Honor, as prosecutors, we do hold with high regard issues to do with fundamental rights and freedoms of suspects, and particularly the freedom from torture. And when counsel had the first opportunity to raise this before the learned magistrate at Jomo Kenyatta, that was never done. We are now hearing of it here, issues to do with torture.
Was there an order made for treatment?
Yes, there was an order made for treatment.
Yes.
And I'm informed by the IO, one of the IOs in this matter, that in fact the suspect was attended at the Ruaraka police station by a police doctor. And that matter was left to rest at that, Your Honor.
Were the medical documents that he seeks to have?
We had not anticipated that this issue will come.
But you can avail.
But now we can always avail them. We had not anticipated that this will come because we had settled that matter and Learned Senior had withdrawn that application.
Okay.
Yes, Your Honor. And my lady, issues to do with intellectual applications at this stage of plea taking have been frowned upon by our courts of law. None other the Supreme Court of this country, Your Honor, my lady, have said that when courts are faced with such allegations, grave as they may be, the Supreme Court in Khalid Hussein, petition number 21 of 2017, Khalid Hussein and 16 others, the court held that such allegations can now not be the basis to forestall proceedings that are properly before a court with jurisdiction. Such grave allegations can be effectively handled at another forum. So that we are not downplaying, my lady, we are not downplaying these allegations. They are serious. We are not downplaying them, but we are saying, let this be litigated at the right forum. We are here to take plea. For the murder of someone whose family and the victims are waiting for answers as to what exactly happened on that fateful day.
So do you want the plea to be taken, then mental assessment?
No, we are saying let us proceed with the formalities. Let us go for mental assessment, then we can come and take plea. Then thereafter, my lady, these other issues to do with the release of items, we can always address them during the trial. So that, my lady, if we find that there are some items we do not need as evidence, we will, as we have always done, release them back to the suspect. But if they are to be used as evidence, then, my lady, will just do the right thing. We'll do what the law demands of us. Lastly, my lady, with regard to the affidavit, now that it was mentioned, we have not filed it. My lady, again, as we speak, there are several other suspects in this matter that will be presented in several courts. That is the JKIA following day, that is on the 6th and on the 11th of this month, for possible closure and some for possible charges. My lady, there are some that have been presented before your sister, Justice Muigai, earlier this morning for plea. Some 2 suspects. You know, with the severity of witnesses that we are looking at, the sensitivity of the evidence that we are now looking into, the fact that we have collaborators amongst the suspects who are willing to collaborate with us, this therefore means, my lady, that we were not in a position to prepare a substantive affidavit today, because as we speak, there's a witness who's at the moment being interviewed by the Witness Protection Agency for purposes of admission into the program. This pointing towards already interference that is active in this matter. We therefore request, my lady, that we do be allowed time to file an affidavit in opposition to bond by close of business today, and that if there will be need to file a supplementary because of all that is going on with the investigations, that some are still pending, with all that's going on, we'll be allowed leave to file a supplementary affidavit in opposition to bond if need be, because that is a probability, my lady, owing to the complexity and the nature of this matter.
I'll take you back.
Yes, my lady.
The cases still pending at Jomo Kenyatta,
yes,
coming up on 6th and 12th.
And 11th. Yeah.
And 11th.
Yes.
Do they have anything to do with the case before this?
Yes, yes, yes.
How so?
These are actually people who are likely to be co-accused. There are some who are likely to be collaborators, and that's the complexity and the nature of what we are dealing with at the moment. Yes.
Okay.
So they are actually related, so that in the fullness of time, we are likely to have more than 3 accused persons before this court, in the fullness of time. this is also to mean that the two that were presented before the yes, so even that the two that were presented before your sister, Justice Muigai, earlier this morning, are likely as well to end up here.